I'm Stewart Dresner, Chief Executive of Privacy Laws and Business, and I'd like to welcome you all to Privacy Laws and Business's 26th Annual International Conference. It's here today, over the 3 days, we're a group of 200 privacy people from 16 different countries, and I often feel that in my role as a Chief Executive and at this conference, I'm like the curator of an arts festival with exciting sessions in all different places and in Queen's College. This conference obviously is a combination of location, people and content. Of course, content first, but location helps. You may have noticed in our early promotions to this conference, the trees were covered in frost. We had to wait till about June till we got a picture of green leaves, but fortunately that's arrived and we're here now. So I'm going to first of all mention some people in the Privacy Laws and Business team, then talk about a little bit of what we do, then a bit about bridging privacy cultures, and then introduce some of the regulators and policymakers who are here. These are some of the colleagues who you've met or will be meeting over the next few days. I'm not sure whether they're in the room at the moment, but oh yes, Doogie is over here, Doogie Stanford and Robert Wakesell, they're doing reports for us. So the conference has a life beyond the 3 days. We produce a number of reports. Is Laura Lincoln here? I don't know. Ah, over there. Very quiet, very efficient. Laura edits our UK and international editions, and very pleased to have you here. Right, so how did it all... Sometimes people ask me, how did Privacy Laws and Business begin? And the answer is with one simple newsletter back in 1987. Nowadays it looks like this, and we have an international UK publication, both available 6 times a year in paper and electronic formats, and now we have an online search function, and the international edition, we have correspondence in many countries. This is a feature in our June edition, published last month, a list of 99 countries that we have discovered with national data protection laws. About 93 of them cover the private sector. It's increasing every year. 2 years ago it was 76, then it was 89. This year we found 99. And there's 21 countries with bills. And of course you need to survey the territory before you plan your route as a person active in the field. This is the UK edition, and in this case the lead article there is on big data. It's a report on our roundtable with the UK Information Commission in April on big data, and this edition also, we've got a social media article there, and also this UK edition covers both data protection and freedom of information and the environmental impact regulations. This also is available 6 times a year in paper and electronic formats with an online search function. And there's a flyer on our website which covers the whole service, explaining how we report and there's a regular e-news available, which hopefully many of you get. And if this conference is the icing on the cake, then the publications are the cakes, we could say. So in addition to this conference, we have several other meetings during the year. We have what we call Data Protection Commissioner Roundtables. We've held these in many countries. The first one abroad outside the UK was in Spain in 2003, and there's a list there which you can see. And the next event is on 11 Asia countries. It was held in London on the 1st of October, and after that our plans are to have meetings in Italy and Germany. All these slides will be on our website because not all of them are in your folders. These are some other events we've held over the years on various issues, and the people who come to these events are very much like the profile of organisations here, a mix of different types of companies, law firms, consultants. So many of them are indeed the same organisations. Who hosts the meetings? Well, there are all sorts of companies and law firms, and some of these organisations are here now: BP, Hewlett-Packard, Total in France, Bristow's, Covington and Burling, and Ernst & Young and others. And anyone can offer to host these meetings. I'm very happy to accept your kind offers. This is a little bit more information about the Asia event, and we will be circulating a flyer about that, the one in London on October the 1st. Where possible, we aim to run these literally around tables, although the shape of the table is round. It is around the tables anyway, and this is an example of one held in last year, hosted by Norton Rose, with, in fact, on the right-hand picture, there's a little bit you can see Tower Bridge, which links us in with bridging privacy cultures, just there. There's a little bit of iconic bridge. Not all law firms are privileged to have a view of the river, but some other law firms have some very nice views of other places. Not that that's the main criterion we judge by, that's not the main point. So, bridging privacy cultures. Where are the laws? How many are there? Where are the next laws likely to be adopted? Before we consider how we bridge the privacy cultures, we need to look at the countries where there are the laws and the bills, and we're going to look at them in the form of maps. And this work is based on a huge research project conducted by Professor Graham Greenleaf, the University of New South Wales, who is also our Asia Pacific editor. He comes here some years, but not all years. So this is a new set of maps which will be available on our website, and we put them together just for this event. So you can see virtually all of Europe has data protection laws, and for this purpose we've included Israel, you can see there on the east, which has EU adequacy, Morocco on the left, which is moving towards joining the Council of Europe, signing and ratifying the Council of Europe Convention, and Tunisia has a law, but I think it's done neither. It's certainly not, I don't think it's gone to either extent yet. Africa, just a few laws and a few bills, and I should make it clear, this is not an assessment of how well the laws are working, it's just whether there is a law or there is not a law. Lots of changes in Asia. There's a new law adopted in Japan just 5 weeks ago, on the 24th of May, which was to do with the ID number system. And it's rather important because ACT mandates the government to make changes to the current privacy regime, to establish an independent supervisor, to conduct information impact assessments, and decentralise the management of ID numbers to avoid privacy risks. So an important point here is for the first time establishes an independent data protection authority in Japan. China has a series of different laws. We're going to hear more about that in a parallel session today. And India does not have a comprehensive law, but has various bits and pieces. There. Australia and New Zealand are a bit different from each other in the sense that New Zealand has one EU adequacy, and Australia, the last time I heard about it, wasn't terribly interested in EU adequacy, so there's a different attitude there. This is North America, so obviously US, everyone knows, does not have a comprehensive privacy law, but has a whole series of different patchwork of federal laws, state laws, sectoral laws, US safe harbour, of course, the transfers of personal data from EU to the US, and it's also got a very powerful enforcement body in the Federal Trade Commission, which has the power to impose huge fines, and it has done, and is also a member of the Global Privacy Enforcement Network. Finally, Latin America. Most countries either have a law or a bill, and the leading countries from the data protection law point of view are Argentina, which won EU adequacy first, and Uruguay followed more recently with EU adequacy and also has signed and ratified the Council of Europe Convention. And if I've got that wrong, Sophie Krasny from the Council of Europe will tell me. Now, a few words about bridging privacy cultures. How does a common core of privacy principles relate to different societies' cultures? Well, this is a question that Professor Colin Bennett will deal with, so I'm going to move on to the next point. What happens when Western lawyers are brought in to draft a data protection law from a blank sheet of paper? And we will find out, because after the break we have a session from Mark Doutlick and his team from Pinson Masons, who tell us how they did exactly that when they were working on the Qatar law that is in the process of being adopted. Point 3, lawyers often make an assumption that privacy law is the most important and effective way forward. But to what extent should there be room for manoeuvre? And reconciling users' convenience with advertisers' hunger for personal data is a tension behind every mobile app commissioned by companies such as you here as we shall see in a parallel session after the break, where we've got Vodafone and the Information Commissioner's Office. Of course, laws cannot cover every situation, but they do set the standard. So to what extent can public and private organisations fill in the gaps and manage their own privacy policies? We'll find out later today with a session from Birmingham City Council, how they use privacy by design to achieve greater efficiency, reduce costs, and defend against an ICO action. And Varun Shingari from Birmingham is going to tell us all about it. And of course, the role of privacy impact assessments encouraged by the EU reform agenda will assist in the process to help organisations get involved in managing their own privacy cultures. Chief executives are more likely to recruit and support well-resourced privacy managers if they consider that a privacy team will provide a good return on investment. And how does the motivation of maintaining a company's reputation balance with the desire to access and monetize people's personal data? And we've got a session from eBay this afternoon who will tell us how they manage the balancing act as an intermediary between consumers and advertisers. So this will be an interesting session. 2, how to achieve that across different cultures. Is it possible for data protection authorities in different regions to tackle a single company presenting the same problem? And the answer is yes. The Netherlands and Canadian commissioners, Jacob Constam and Jennifer Stoddart, who are here, will tell us how they cooperated in the WhatsApp case, despite different laws and different enforcement powers. Will it be possible to bridge the EU and APEC approaches to protecting privacy when making international transfers of personal data? Peter Shah, Germany's Federal Commissioner for Data Protection and Freedom of Information, will bring us up to date in a session reporting from negotiations in Indonesia in January and May this year to try and find commonalities, where possible, between the EU and the APEC approach. Privacy International is very critical. They're very privacy advocates, very purist, very critical of this process. But there's obviously a balancing act, a balancing thing is needed. 4, sometimes a determined push by an EU commissioner can help consumers in other countries. And in that, we see that in the example of Billy Hawkes, the Irish commissioner, how his work auditing and working with Facebook to improve their policies and to benefit consumers across the EU and even beyond. And CNIL, the French authority, is also doing a similar job working with Google to try and improve their policies and processes. Privacy doesn't exist for us as an isolated subject. It links with other societal issues. And look, so we'll learn at this conference about models of good practice on genetic data and insurance in Canada, a session by Patricia Kosheim, General Counsel at the Canadian Privacy Commissioner's Office. Should we have a right to not have access to our data if, as a result, we become a high risk for insurance companies and therefore have to pay higher premiums? So that's the reverse of the usual assumption in data protection norms. And there's another session in the same parallel, smart meters and smart grids in Austria, which is being given by Dr. Rainer Knerim from Preslimar in Vienna, and he's been doing a lot of work with companies in Austria. And it's a blueprint for the rest of Europe because the smart grids and smart meters are being rolled out across the EU as a result of an EU policy. So we should approach the challenge of bridging privacy cultures with humility. As privacy laws become out of date with a few years, and society's expectation of privacy changes fast. There's no proven way that's best. We're privileged to have here at this conference many of the people responsible for interpreting the trends, finding creative solutions when the laws and regulations need to be applied to new circumstances. And they're active both international organisations and at active levels. And these are the people working in the international organisations. And so we're going to find out about revisions to the OECD guidelines, Council of Europe Convention, and of course the EU Data Protection Draft Regulation, which will occupy about half our time tomorrow. And these are some of the national policymakers who will be with us from several countries, and so we'll be seeing them in the programme. And there are other regulators who are here not speaking, but they've come along to learn like all of us, and we're very pleased that you come along to join us here.